for coming tonight. My name is Adrienne Spies. I'm with the law firm of Krupnick and Spies, and tonight we will be talking about What Am I? A Guide to HOAs. What is a homeowners association? Well, basically, a homeowners association is an entity organization. That's why we call it an association. A homeowners association can take many different forms, and we'll be talking about the different types of forms that a homeowners association can take. A homeowners association is different than maybe a type of community where you have deed restrictions and any owner in the community can enforce them, but there isn't an overarching association or entity that enforces things. So when we're talking about a homeowners association, we're talking about an entity that can enforce, that has maintenance responsibility, likely imposes dues or assessments, and most of the time those are mandatory, but that's not always the case, and we'll talk a little bit about that as well. Types of homeowners associations. The first thing I want to caution you about is you cannot tell the type of a homeowners association just by looking at it. I don't know how many times I've been told, well, this is a townhouse association, or this is a patio home community, or this is an apartment style condo. Well, those are all descriptors of the physical community, the structures, but the physical community and the structures don't always match and don't have to match the legal, technical categorization of the homeowners association. So there are several types. One is a planned community. That is the type that you're probably going to be most familiar with, planned communities and condos. In a planned community, the association owns the common area, and that is key. Now, a planned community can also be something where the association has roadway easements that they have to maintain, but those are so few and far between that we won't be spending a lot of time on those tonight. But homeowners association, a planned community, the association owns the common area, and that's key. Another key factor is that all owners are mandatory members and required to pay assessments. So there are some homeowners associations where membership is not mandatory, assessments are not mandatory. So those associations are not planned communities. So planned communities, the requirements are set forth in statute, and these are two of them. Condominiums, on the other hand, each owner owns an undivided interest in the common elements, and it does not matter how it looks. You would think that most condominiums are 3-4-story buildings. We have several of those in Scottsdale. However, there are communities that you would not think are condominiums, and they actually are. For instance, I've represented a community before that is quite rural. Actually two. One where the owners owned an undivided interest in the irrigation system, and it was rural and farmland, and it was a homeowners association that was a condominium because each owner had an undivided interest in the real estate, which was the irrigation system, and the irrigation system was the common elements. Another community that's also rural by chance, the owners have an undivided interest in the well system. And so the well is the common elements, the well system, and so they are a condominium. So that is why I say you can't judge a book by its cover. Same thing with a townhouse community. A townhouse community or a patio home community, some of them are condominiums, some of them are planned communities. But it's really important to know what your community is, because the statutes on planned communities and condominiums are different. They have many, many similarities, especially when it comes to how the association operates in terms of meetings, records requests, and things like that. But in terms of insurance, maintenance, budgets, they're different. A cooperative or a co-op. Now, you will find these more often back east with your co-op buildings. In a co-op, you don't own any physical real estate. You own a right to occupy. In Arizona, there are no statutes on co-ops like we have for planned communities and condominiums. The only laws or statutes, I should say, for co-ops would be the Nonprofit Corporation Act. So if you happen to live in a co-op, then you might think you're lucky or unlucky, depending on your perspective, because there really isn't much guidance for you, but then there's also not much constraints. So I've represented a few co-ops before, and for some reason they tend to be mobile home communities, and I don't know if there's any correlation or if that's just a coincidence. Master association. Oops, I went the wrong way. Sometimes members are part of both a master association and a sub-association. If you are a member of a master and a sub, you probably already know that. There's several good examples here in Scottsdale. McCormick Ranch is a good example. Scottsdale Ranch is another one. Troon is another one. So there's quite a few homeowners associations here in Scottsdale where there's a master and sub-association. The important thing to remember about a master and sub-association is that the master is always going to control. Now, sometimes the master will defer to the sub-association, and sometimes that's the case, especially with architectural control, because a master association that has thousands of homes in it and many sub-associations in it will have some general standards, but each neighborhood or sub-association may have very specific. So, for instance, a master association may say the color palette needs to be desert colors, neutral. Well, you might have a sub-association that says all our homes, our townhomes, are Navajo white, and that's it. So the master association, their CC&Rs, articles, bylaws, rules, architectural regulations, they will all take precedence in case there's any conflict between the master and sub. However, the sub-association can always be more strict. Another example might be parking. The master association may say parking is allowed on the streets except for overnight, and overnight is defined to be between midnight and 5 a.m. Well, if you're part of the sub-association and you have a community that has very small streets and two-car garages and big driveways, the association may decide, well, we don't really want parking overnight on the street, or we won't want parking at all except for temporary for a few hours at a time. So the sub-association could be more strict. If you live in a master and a sub, then you're probably paying assessments to both, so you also have that to contend with. So you have two sets of governing documents and two assessments. So homeowners associations have a few sets of authority. They're basically the governing documents, statutes, and case law. So the first thing we're going to go through are the governing documents. The Articles of Incorporation. Most associations are nonprofit corporations, but not all. You probably have a few in Scottsdale that are not incorporated as a nonprofit. More often you will find associations like this in Sun City. Those were some of the first homeowners associations built in the nation and in this state, and they weren't always incorporated as nonprofits. Back in the 60s, that wasn't the norm. Nowadays, if a homeowners association is formed, it's almost certainly going to be made a nonprofit. So the Articles of Incorporation are the document that creates the nonprofit. Sometimes there's confusion about an association being nonprofit. Does that mean they have to pay taxes? Are they tax exempt? Just because a homeowners association is nonprofit does not mean they're tax exempt. What a nonprofit corporation means is that any proceeds or profit or overages or extra money that the association has at the end of the year needs to be kept internally. A nonprofit corporation is not allowed to issue dividends. So that's basically what that means in terms of monetarily. A for-profit corporation could give out a dividend, a nonprofit corporation cannot. Homeowners associations are generally not tax exempt. There are some homeowners associations that are tax exempt because they have applied for that with the IRS. They've had their CPA apply for it and they meet the criteria. Some larger homeowners associations are tax exempt, but most homeowners associations are not tax exempt. They have to pay taxes. They generally don't have to pay a lot of taxes unless they get some sort of windfall during the year. There are special tax categorizations for homeowners associations, and your CPA could talk more about that, but generally associations do have to pay taxes. Bylaws. If you are a nonprofit corporation, you are required to have bylaws. Even if you're not a nonprofit corporation, you need bylaws. Why do you need bylaws? Because they provide so much information. You wouldn't know how to operate. You wouldn't know what to do if you didn't have any bylaws. They govern how is the board elected? When is the association supposed to have its annual meeting? What are the powers and duties of the board? How many directors are we going to have? What are their qualifications? What are their terms? Are we having 2-year terms? Are we having staggered terms? Do board members all need to be owners or members in the community? Can they be non-owners or non-members? Must they be spouses of members? Things like that. Powers and duties of the board. So much information is in the bylaws. And that's the document that governs, how the association operates, the day in, the day out. The CC&Rs, they're the most important governing document of the association. They are recorded against the property and they run with the land. So that's sort of legalese, but you'll notice at the top right-hand corner of your CC&Rs, if you have the front page, if you've lost the front page, you might not see this, but at the top right-hand corner or in the very bottom of the back page, if you have really old CC&Rs, there will be a recording stamp, meaning they are recorded with the county recorder, and here it would be Maricopa County Recorder, and they are a public record for all to see, and they attach to or run with your land. So they are stuck to your lot, and they're going to stay on there unless and until amended or revoked pursuant to the terms of their own CC&Rs. The articles are not recorded. The articles are filed with the Corporation Commission, and the bylaws generally are not recorded or filed. Sometimes there are exceptions to that just because of practice, but there's no requirement that bylaws or bylaws be recorded or filed. CC&Rs, they are considered a contract between the association and the owners. If you think of them as a contract, you realize how impactful and serious the CC&Rs are. It also informs us as lawyers as to how the CC&Rs are supposed to be interpreted and treated. Now, we're not going to take answers, but just by a show of hands, how many of you think that it is necessary to sign the CC&Rs in order for you to be bound by them? So does the owner who's purchasing the lot have to sign the CC&Rs in order to be bound by them? No, they don't. There's actually case law on this, specifically on point in Arizona, that says that purchasing is the same as if you signed on a dotted line. So the CC&Rs, as you probably already know, they set forth the restrictions for the use of the land. They'll also set forth things like how much assessments the association can charge, How much can be increased? Can a special assessment be charged? If so, for what purpose? And what kind of approval needs to be obtained from the owners to charge a special assessment? Now, rules and regulations. A lot of associations have rules and regulations. They are supposed to support and supplement the CC&Rs. Most CC&Rs, or sometimes bylaws, or both, will empower the board to adopt rules. The rules may cover just the common area, or they may extend to the lots or the units, depending on the power. If the CC&Rs only give the association the authority to adopt rules regarding the common area or the common elements, then the board doesn't have the authority to adopt rules regarding the use of lots. This is somewhere where I see a lot of associations getting in trouble, per se, or doing things that are not in compliance with their declaration. Do you think that it's possible, if you have CC&Rs and you don't like something in the CC&Rs, to just adopt a rule to address it? No, unfortunately. The rules supplement, like I said, the rules supplement and support the CC&Rs. The rules cannot contradict the CC&Rs, and the rules cannot generally add new restrictions unless the board's given the authority to do that. Also, rules must be reasonable. There is case law on that anytime the board is exercising its discretionary powers, it must do so reasonably. Another type of association governing document are the architectural and landscape guidelines. In associations where a committee or the board has to approve or has the authority to approve new structures, alterations, new landscaping, taking out trees, putting in new plants, that sort of thing. An association will often have architectural guidelines and rules to help owners know what are the types of projects that are likely to be approved and what are the types of projects that are a no-go. Associations will say, no pink granite, all the granite has to be a certain size, 3/4 inch, and it has to be gold or brown or things like that. That helps members have some guidance so they don't submit something that's never going to be approved. The plat. The plat is the forgotten document, but I love the plat. The plat has so much good information on it. It often has information on responsibilities for maintenance. Sometimes it'll say who's responsible for maintaining drainage easements. It might say who's responsible for maintaining landscaping along the perimeter of the community, who's responsible for certain walls, where things are located. It has sometimes a lot of information on it. Sometimes, if it's an older community, it has very little information on it, but a lot of people forget about the plat, and so I just want to highlight it a little bit so that you remember that the plat is one of the governing documents. It's actually one of the more important ones, because pursuant to the Condominium Act statute, the plat is a part of the CC&Rs, and according to case law, which would apply to anything that's not a condominium, the plat is a part of the CC&Rs. So the plat and the CC&Rs are on equal footing and should be read together. There are a couple principles of contract interpretation that would apply if we are trying to read the plat and the CC&Rs together. One is which, if we can come up with an interpretation that harmonizes provisions and does not create a conflict, that sort of interpretation is going to be favored over all others. So don't forget about the plat. Maybe you've never seen your plat. If you haven't, it's worth going and pulling. You can find the reference to it. Plats are referenced by their book and their page number. You can find reference to that most likely in the CC&Rs. Then you can go either to the recorder's website or the assessor's website, and you can find the plat through there. county recorder, county assessor, just to clarify that. So the hierarchy of governing documents, the declaration and the plat, which we just talked about, the articles then would be next in line, the bylaws, rules and regulations, and architectural guidelines. The declaration is recorded against the property. That is why it takes precedence. Between the articles and bylaws, the Nonprofit Corporation Act actually says that the bylaws can basically contain any provision that doesn't conflict with the articles and that doesn't conflict with statute. So the bylaws cannot conflict with the articles. If they do, then any conflicting provision is void. So we've gone through the governing documents. Those govern homeowners association. There are also state and federal statutes, many of them, that govern homeowners associations that you need to be aware of. A lot of statutes will govern how the association operates. So there's provisions about when can the association have an executive or closed meeting versus when can it have an open meeting. What does it need to do in advance of calling an executive session meeting? How often does an annual meeting need to be held? That's covered by statute. The use of absentee ballots versus proxies, that's covered by statute. Different laws apply to planned communities and condominiums than other types of associations. So please be aware that the types of laws that govern the city council are going to be slightly different than the types of laws that govern a homeowners association. You will find some similarities, but it's not exactly the same. So please keep that in mind. Also keep in mind that we are in Arizona. I sometimes get articles forwarded to me from clients, and they're from attorneys in California, or they cite California law, which is totally different than Arizona law, and a whole beast in and of itself. So, Planned Community, Condominium Act, Nonprofit Corporation Act, all Arizona laws, and then we also have fair housing laws, which I'll talk a little bit about. Another type of law that affects how associations operate are the records review law. Generally, members have a right to review association records. Some records can be withheld. Owners have a right to review them in 10 business days from their request. The association can charge for copies, but cannot charge just to view them. It used to be that associations would foreclose for fines, and the legislature did not really like that because the homeowners association is the one imposing the fine, and then they decided when to foreclose, so it was too much like the homeowners association acting as the judge, the jury, and the executioner. So with regards to fines, because fines are discretionary, we no longer as associations foreclose based on fines. So not all associations are governed by the same laws. Not even all associations are planned communities or condominiums. We talked about the co-ops. We talked about the communities where membership is not mandatory. There are several of those. Sun City HOA is a good example of that. There are some small condominium associations within Sun City, and the owners within those are mandatory members of their condominium, but Sun City HOA is not a planned community because membership is not mandatory. I don't have a good Scottsdale example for that. So if I did, I would use it, but you're probably all familiar with Sun City because they're so big, and they're one of the first HOAs in the state. Case law. Before I go to case law, I did want to mention a little bit about fair housing. All housing communities, all HOAs, homeowners associations, whether you're a planned community, a condominium, neither, you are going to be subject to the Fair Housing Act. And there's entire presentations about fair housing, and it's sort of complicated and actually very interesting. The fact patterns are always so interesting. But just as a basic idea, the Fair Housing Act applies to housing communities. It applies to residents of the property, regardless of whether the individual is an owner or a tenant or just a person who lives there that's not on the deed. Fair Housing Act applies. And we can't discriminate against people who are residents because of national origin, sex, religion, disability, those sorts of things. Familial status, which means children living with them who are 18 years of age or younger. The exception for that would be age-restricted communities can discriminate against children, can discriminate against families living there with children. So then case law. Every year there's a few cases at least that come out of Arizona that interpret either statutes or just the general law, and we call those case law. Case law is judge-made law. So a controversy comes in front of the judge by a lawsuit, and the parties argue about what is fair, what should be, and they refer back to cases, and they refer back to legal principles that have been around since maybe even 1600s, 1700s in England, and then the judge makes a decision, and that decision becomes part of the body of the case law and something that generally applies to everybody in Arizona in a similar situation. They will sometimes interpret statutes. They will sometimes interpret provisions of an association's governing documents. And they'll sometimes govern things that apply to homeowners association that aren't in the governing documents really at all, but just are harkened back to principles of the law that have been around for many years. Okay, so on the case law, a few examples of that. You know, we have a case in Arizona that is an interpretation of a CC&Rs where a community and an owner got into a dispute over a driveway that he built. And the CC&Rs say no structures can be constructed without first getting approval of the board or the architecture committee. Well, he built a driveway or laid a concrete driveway, and then he argued that the driveway wasn't a structure. And there was no definition of structure in the CC&Rs, so it went up to court and got in front of a judge, and the judge decided that if there isn't a definition of a term in the CC&Rs, then you go to the dictionary definition of it, and that a structure is something constructed. So his driveway was constructed because it wasn't organic, didn't show up organically, and he did in fact need approval. Another type of case is one where we hearken back to legal principles that are around and maybe borrowed from other situations. One is Martinez's case, where the principle came out of that is that the association has a duty to keep the common elements in the common area safe. And the situation was that Martinez was at, I believe, a graduation party, but he was at a party. He was a guest of somebody who was living in the apartment complex, and there were some known ruffians, I guess is the word I'll use, ruffians, in the parking lot, and the association knew that there was issues with security, and they had recently cut back on the security guard hours of patrol. And Martinez in the parking lot, when the security guard happened to not be on duty, got into an altercation with somebody, and he was shot. He wasn't killed, but the whole case came up because he said the association should have done something, and the association was arguing, well, they don't control the actions of a third party, and the court basically said, well, the association has exclusive control and management of the parking lot because it was common elements, and so the association had a duty to keep it safe. And that borrowed from landlord-tenant law, where that principle was already in place, where the landlord, because they control the common areas, they're responsible. We also have case law talking about Fair housing, there's a good, robust area of case law for fair housing. So I'll just go with a show of hands, and if you're watching along at home, you can just answer in your own head. So if you are in an age-restricted community and you have a couple that meets the qualifications for the age-restricted community, but they have a disabled son who is underage, do you think that the disabled son would be allowed, per the Fair Housing Act, to live with the parents? Yes, I'm getting some nods, yes, and that is a case where the name of the couple was Canaday, Canaday, I believe, and so there's other provisions about whether or not the association is subject to fair housing or Americans with Disabilities Act, and that all turns on whether or not the portion of the community is open to the public. So there's a case on that. There's a case on parking an RV in the community, and is that necessary for somebody who's disabled to use and enjoy the community. So there's a great body of case law in Arizona. Other states probably have more, but Arizona has a pretty decent amount of case law. Now, a couple of things we're going to talk about that homeowners associations generally, as a group, deal with. There's 3 things that almost all homeowners associations are going to deal with or govern and control. And so I'm going to talk a little bit about those. One of them is maintenance and insurance. This is a huge deal in condominiums, a pretty big deal in a lot of townhouse communities, and a little bit less of a big deal in your regular planned community where you have your single-family homes. The main thing to remember about maintenance and insurance, well, the first thing you want to find out is there any law on point? And the first place to look, if you're a condominium, is the Condominium Act. The Condominium Act has a couple pages, probably, of provisions that deal with insurance and maintenance. So that is the first place to look, because if you ever have any conflict between the statute and your governing documents, the statute's going to control. So if you're going to be looking at something, you're going to be looking at several documents, the first place to look is the statute, because it's going to control. And then you would look at the CC&Rs and the plat, because then and then you'd look at the articles and the bylaws. And that way you're working from top down, and you don't end up reading things that later get contradicted. In a condominium, the Condominium Act requires that the association carry insurance on the common elements, and says that the association can carry insurance on the units. The Condominium Act also says that any insurance carried by the association is primary, takes precedence, it's the first one. A lot of associations get in trouble when they have a water leak and the association's insurance would cover, yet they tell the owner, file a claim against your own insurance. Now, this isn't the association trying to get out of responsibilities always, although sometimes it might be, but a lot of people just don't realize the provisions about insurance that apply and that are governed by the Condominium Act. The Condominium Act says if insurance coverage is provided, then the association is responsible for making the repair as well. So associations have a lot of responsibility when it comes to insurance in condominium. Now, what do the governing documents require? For instance, if we're talking about a condominium, you can have different things. You could have an association that says, and I did have an association that specifically requested that the association maintain insurance on the units and that the association be responsible also for ensuring any improvements and betterments installed by the owners. In this community, they just decided, instead of having each owner have to carry their own insurance for certain portions of the inside, they said, we just want the association to insure it. We want it blanket. We want it covering everything. Now, some documents may say that the association is only going to carry bare walls. That generally means, each insurance company is different and each insurance company provides a little bit different package of insurance, but that generally means that the association is not going to cover the carpeting or tile or hardwood floor. It's not going to cover the finished ceiling, whatever that may be, and it's not going to cover the wallpaper. Sometimes that means it covers the drywall and sometimes it doesn't, just depending on the policy. When it's a bare walls policy, then everything inside of that is not covered either, and that is the cabinetry, baseboards, things like that. The cabinetry can get quite expensive. So whether or not the association covers that is really important, and that will generally be governed by the documents because the Condominium Act leaves that up to the association to decide. One important takeaway from tonight is that insurance and maintenance responsibilities may not be the same. In fact, it's often the case they are not the same. Generally, in most of your condominiums, you will find that the owner has to maintain their unit. They may even have to maintain pipes, water lines that serve their unit, but that the association maintains the common elements. Well, if the association insures the unit, then if there is an insurable event, like a water pipe bursts, then the association will likely end up making repairs to the unit. If something happens that's just normal wear and tear, or something that's not insurable, maybe just like a slow leak, for instance, underneath a cabinet, if the pipe underneath the cabinet, your kitchen sink, you have that cabinet where you have your garbage disposal, if you have a pipe under there, just a slow drip, drip, drip over 10 years, and eventually all the boards are warped and you might have mold, that's not going to be covered by insurance, and so then you would fall back on the normal maintenance responsibility. So it is something that's tricky and can get associations in trouble. The best thing to do is to talk to your attorney early so you understand, so that when a water leak happens, you're not scrambling to try to figure out what to do and you're not doing the wrong thing. Sometimes when you do the wrong thing, even if you back out and you start doing the right thing, the owner has gotten so irritated or angry that just makes them harder to deal with the rest of the situation. So it's nicer for everybody and less stressful if you have an idea up front on what you're supposed to do. Another big question I always get is who's responsible for the insurance deductible? And the answer to that question is primarily going to be governed by the CC&Rs, but may also be governed by the Condominium Act as well. And the reason for that is the Condominium Act doesn't specifically say who's responsible for paying the insurance deductible. So if the CC&Rs say something, then likely that's what we're going to go with. If the CC&Rs don't say anything, then we have to analyze both the provision that talks about how assessments are allocated, and we have to look at the Condominium Act. Associations sometimes assume that if the damage was to somebody's unit, that they are the one who have to pay, or if an owner's pipe broke, then they have to pay the deductible, regardless of whether their unit and or their neighbor's unit was damaged. That's not always the case. Most CC&Rs, however, will say if damage was caused by someone's negligence or willful misconduct, then you could charge the deductible back to them. So I have a story about when a deductible would almost certainly be appropriately charged back to the owner. There was once a condominium association that had a huge water leak, or flood, I should say. It's a little bit better term. A huge flood in the condominium on New Year's Eve. What had happened was there was an owner of the unit. He lived there with his adult son and his adult son's girlfriend. Well, the son broke up with his girlfriend, and she didn't take it well. and she stuffed either socks or washcloths into the toilet and clogged the toilet and flooded everything up. Well, even though the unit owner himself didn't do it, unit owners are responsible for the actions of their residents, their tenants, and their guests. So, moral of that story is be careful who you're friends with, or you might be paying that deductible. A lot of times the deductible could be $10,000, $15,000, $20,000. So it is a big deal on who's responsible for paying it. All right. Another thing that homeowners associations all do, if you're a condominium or a planned community, and that is you impose assessments or fees. So budget. How do we come up with the budget for the assessments and the fees, and how are the fees decided or determined? Once again, the first thing we want to do is we want to see, is there any law in point? That is because the law is always going to take precedence over the governing documents. Well, you might be sensing a theme here because we spent most of the last few minutes talking about the Condominiums and Condominium Act. Once again, the Condominium Act has provisions about budgeting. The Planned Community Act doesn't have a provision about budgeting, but does have a provision about increases. So what the Condominium Act says is, unless the declaration explicitly gives the board the authority to adopt and amend budgets and determine the amount of the assessments, then the budget and the amount of the assessments, I mean, these things go hand in hand. The term budget is used, but really we're talking about the budget which drives the assessments. Unless the board has the explicit authority to make those decisions in a condominium, the board has to submit the budget to the owners, and the owners have to ratify it. That's the language in the Condominium Act. However, the word ratify is somewhat misleading. It would really be more accurate to say that the members of the community have a right to reject the budget. So the budget has to be sent out to the members, and then a meeting is called. And it doesn't matter whether you get quorum or not. If the budget is going to be approved or deemed approved unless a majority of the owners reject it. So ratifications insinuates that there's some sort of affirmative approval of the budget, but that's not really what happened. It's really more accurate to say that the owners are given the opportunity to reject the budget. Now, if that happens, then the budget from last year is going to stay in place until a new budget is ratified, or more aptly, not rejected. So the Planned Community Act gives the association a different type of restriction, and that caps increases from year to year. Now, this is a 20%, which is pretty significant. So it doesn't come up in associations very often. But if an association wants to increase the amount of assessments actually charged in 2018 more than 20% over what is actually charged in 2017, then they would need to get the approval of a majority of all members of the community. After you've looked at the statutes, then you will want to see what do the governing documents require or provide. They can be very different than what is provided in the statute. If the CC&Rs are less restrictive than the statute, then the statute is going to control. If the CC&Rs are more restrictive, then the CC&Rs are going to control. For instance, some CC&Rs, especially older CC&Rs, might limit increases to the amount of the increase in the CPI, which lately has not been great. Some associations will have a 5% increase that they're allowed to do, or 10%, or some combination of maximum and actual, which I'm going to talk about here in a minute. You want to know the difference between the maximum annual assessment and the actual annual assessment that's being charged. The reason for that is some CC&Rs will talk about the maximum annual assessment, and that acts as a ceiling, and the board can increase the assessments anywhere up to the ceiling. Now, what is actually charged is important in the Planned Community Act, because the Planned Community Act is not concerned with what the board could have charged, but what the board actually charged. So here's an example. Real numbers are helpful. So here's an example of a maximum annual assessment if you are going to have 10% increases each year. So these are the numbers, and then the board decides, though, you know what, we don't really need an increase from 2008 to 2009, so we're not going to increase, and then they only need a modest increase in 2010. But something happens in 2010. Maybe the AC unit went out in the clubhouse. Maybe there was a hailstorm and insurance, didn't cover the cost to fix, replace some trees that were blown down, something like that. So then they need to increase. Well, they can increase by this amount of money. That's 20% increase, roughly. They don't go above their maximum that they would be allowed to charge under the assessments. So they can go up to the 252. So now it is time for questions. So I will be reading the questions that have been submitted to me. Well, so as not to spend too much time reading them, I'm just going to answer them all in order, so I don't sit here and think about in what order to answer them. So they'll all be answered, maybe not in the most logical order, or maybe the order doesn't follow the presentation, but I'm just going to answer all these. So first of all, case law. Is there a way for homeowner to research at law library? I believe the answer might be yes. I would recommend, if you're interested in searching for case law, one thing you could do is you could start off with the Google search, or Google Scholar is better. So it's still Google and it's still free, but they try to cull the results to be something more scholarly. So if you know the case that you are looking for, like the case that had to do with the shooting in the parking lot, that's Woodmar versus Martinez. If you wanted to go pull that case, then you could Google or search in Google Scholar, Woodmar versus Martinez, Arizona, Supreme Court. This is a Supreme Court case. And you should probably be able to find it. Generally, sometimes I will start with Google. If it's kind of an area of a law that's kind of on the periphery to homeowners associations, and I need to get kind of feelers and get kind of my sea legs before I get really into the case law, sometimes I will start with Google. And you might find other attorneys that have written articles now. I will tell you, attorneys are just like any other profession. There are some really good ones, and there are some not so good ones. So you as a layperson might not have very good indication on whether the article is a good article or not. But you can find the cases that you're looking for sometimes. If you see a PDF, like if you Google and you see a PDF on the side, then you know that might actually be a copy of the case. And then you might want to call the law libraries around town and ask if the public's allowed to come and view cases. I don't know the answer to that question, but that's what I would do. I would call and ask. 2, changes to common area. Can board of director change a gate location or new installation of fence without approval? The answer to that question is there's a fairly good chance that they can, I'm basing that answer on the numerous CC&Rs I've written. Most CC&Rs give the board of directors pretty broad latitude and authority to manage and maintain the common area. Although homeowners have a right and easement of enjoyment and an easement for ingress and egress, I've never really seen CC&Rs that say owners have a right of ingress and egress through the west side pedestrian gate. So if there's still access being provided, a lot of times the board has the authority to make that change. Now, I will say there are some CC&Rs that have a provision in them that says that the board cannot change the use of the common area without getting approval of the members first. So this question is entirely driven by the governing documents. And I can give you an idea of what I think the answer would be in most homeowners associations, but the answer to that question is going to be governed by your CC&Rs and maybe your plat as well. 3, can gate be installed in common area to keep out dog walkers? If so, what is needed? Okay, I'm going to go ahead and assume that this question has to do with people who don't live in your community coming into your community. If that's the case, the answer is generally yes. Generally, people who are not guests and who are not residents would be considered trespassers, and you could generally keep trespassers off your community. If you have public streets, it might be a little bit different question if people want to walk through the streets because they would be public. But if people come in, if you have private streets, that's different. Or if you have parks that people like to come and use, you could prevent non-residents and non-guests of residents from using your common area. And for a variety of reasons, that might be a good idea to do so, and that's something to discuss with your attorney more closely. What does the board of directors have to disclose about its members to the Arizona Corporation Commission? Not much. Basically, when you file articles of incorporation, one of the things that you have to provide in your articles is whether or not the organization will have members. A nonprofit corporation can have no members. Homeowners associations, of course, do have members. There's really nothing about the membership itself or individual members that need to be disclosed. Every year when the association files its annual report, it needs to disclose the board members, but there's really nothing about the members themselves. So you disclose your board members, but that's not about the general membership themselves. What is the penalty if a board member does not disclose their bankruptcy? Well, that is a question that I am unfortunately not prepared to answer tonight. It's a pretty specific question. People have to, I'm trying to think back to all the questions that board members have to answer when they file their annual report, or specifically when they incorporate. There are questions about, have you been convicted of fraud? Have you filed for bankruptcy? Have you been convicted of crimes that I would generally associate or categorize as white-collar crimes? So those are things that have to be disclosed when a community is incorporated. Now, the penalty for not disclosing things like that, I unfortunately don't know. I guess I might say fortunately, because I've never dealt with that before. But I'm sorry, I don't know the answer to that question. Foreclosure, $1,200 past due. Can't HOA boards place a lien on the property if dues are not paid and the owner is $1,200 behind? That is an excellent question. Excellent for 2 reasons. 1, the homeowners association, a planned community or condominium, has an automatic lien against the property for the assessments the moment they become due. The lien is automatic. That is per statute. That's going to be in most CC&Rs as well. So that's great because the association lien in Arizona is really strong. It's only, typically people say it's second in line, technically it's third in line. So if there's any government or tax liens, that's first. Then the first mortgagee is second in line, and then the homeowners association. So most of the time we're not dealing with any sort of government, IRS, or any tax lien. Most of the time we're just dealing with the first mortgagee. So the association's lien arises automatically. It does not need to be perfected, which is a legal term meaning you don't have to record another notice to make the lien effective. Now, associations will sometimes record notice and claim of lien just as extra insurance, just as extra notice, and as long as the information in that notice is accurate, then there's no harm in doing that, but it's not technically necessary. However, most association attorneys that practice in collections, they will record a notice and claim of lien early on in the stages. Now, if the amount of assessments becomes delinquent in the amount of $1,200, or if it's been delinquent for a year, then you can foreclose. So your lien arises automatically. The $1,200 is the trigger for foreclosure. And that is all of the questions that I have. So that concludes my presentation. I appreciate you listening and watching, and have a good night.